3, Robert Eli Stanley, appellant versus Georgia. Mr. Sparks, you may continue with your argument.
Mr. Chief Justice and Honorable Justices, at the recess yesterday afternoon, I was just completing my response to questions by Justice Brennan, as to the evidence of scienter, and I had practically completed my summary of the circumstances which we feel justified a jury to find that this defendant knew of the obscene nature of the matter. I just want to elaborate in one...
You really aren't arguing that, are you? That he knew it was obscene? You're just arguing that he knew the contents of the film.
That's right, the contents of the film. That he knew the contents of the film, of the obscene nature of the film. That is the way the Georgia statute reads, I believe. I just want to point out two things in relation to his statement, and I'll move on to something else. In his unsworn statement, he attempted to explain his possession of the films in a manner consistent with lack of knowledge of the contents, and I submit that it was unreasonable explanation, somewhat unreasonable in two respects. First, he said that a friend brought the films by and left them with him, saying that he wanted the appellant to view the films. I submit that it's somewhat unreasonable that films would have exchanged hands without some explanation on the part of the unknown friend or some query on the part of the appellant as to what kind of films are they, particularly the small 8mm films in the can with a homemade label. I feel quite sure that if anyone came to me and said, "I've got some films I want you to see," I'd say, "Well, what are they? Films of your fishing trip or your family or..."
Well, what if you asked him to film shop?
Then I think you...
That's why you said, "Oh, that's interesting." Would you know, would you have any real clue that they were seeing films?
I think that would warrant further inquiry, Justice White.
Maybe. What evidence is that there was any further inquiry or any further investigation of what the films were?
There is no evidence because, of course, this was an unsworn statement, and the state was not allowed to cross-examine him or go into it without his consent unless he voluntarily submitted himself to cross-examination.
Well, the state had the burden, didn't it?
Sir?
The state had the burden of proof, didn't it?
Yes, sir, the state has the burden of proof, Your Honor, but I think this is both federal and state law, as I recall from my days as an assistant U.S. attorney, that where the defense goes ahead with an affirmative defense, then not the burden of proof, but the burden of making a reasonable explanation shifts to the defendant. And that leads me to my next point, and that is that he did not identify his friend.
Stanley,
he neither produced him nor identified him by name.
In that statement, he also said, "I never saw the film before today. I never had shown them to anyone, so help me."
Yes, sir, that is true. And I want to point out in that connection before I pass from this subject, the case of Smith versus California, which this court decided, in which a defendant was convicted for the offense of bare possession of obscene matters under California ordinance, which had no element of scienter as interpreted by the California Supreme Court. And the court said, in an opinion by Mr. Justice Brennan, "We might observe that it has been some time since the law viewed itself as impotent to explore the actual state of a man's mind. Eyewitness testimony of a bookseller's perusal of a book hardly need be a necessary element in proving his awareness of its contents. The circumstances may warrant the inference that he was aware of what a book contained despite his denial. And I submit that those quoted words are pretty analogous to the facts in this case. We are relying on the circumstances. We have no direct evidence that he saw, that he even knew what the films were, but we submit that all of the circumstances, the impending party, the films concealed, the title Young Blood, his rather inadequate explanation.
I'm really interested. How does that title suggest anything? I don't get this. Young Blood? What's that suggest? Or is it my age? I don't know.
Well, I think it suggests sex, Your Honor. We normally associate sex with young blood, with young people.
I guess it is my age.
I want to pass on to another point. I gathered yesterday from the questions asked my worthy adversary, Mr. Asanoff, that this court has not yet viewed the contents of the film, which were transmitted to this court by the direction of the Georgia Supreme Court. I wish to most respectfully and humbly urge this court to view the films before ruling on the case.
Do you think we have to view the film if there are? Do you think we have to view the film if there are constitutional bases that don't relate to the subject matter of the film for disposing of this case, such as the question of mere possession or the search and seizure question? How would you want us to view the film?
That was going to be my very next statement as to the legal reason why I feel that the film should be viewed.
Even if we think that you can dispose of this case and must dispose of the case on the possession ground or the search and seizure, Fourth Amendment ground.
Yes, sir, I do for this reason.
Tell me why.
This court, or the majority of this court, has consistently held in obscenity cases from Roth on through Jacobellis, Michigan, Ginsburg, Memoirs, even Redrup, I believe, and the last Ginsburg case in 1968, that obscenity is not protected by the First Amendment to the Constitution. And if the court views these films and finds that they are not only, that they are not borderline obscenity, but are hardcore pornography.
If this is obscene, we should not reach the Fourth Amendment question?
Should not reach the First Amendment question.
The Fourth Amendment question, search and seizure.
Oh, no, sir, but I'm not saying that. I think, well, as a matter of fact, I am not absolutely certain, Justice Stewart, that the search and seizure question is actually before this court, because it
Fortas,
is
this is Stewart.
Sir, oh, Mr. Fortas, excuse me, I'm sorry. Search and seizure is not an appealable question. The court noted probable jurisdiction without restricting the question to the only appealable question, which is the constitutionality of the Georgia search and seizure, the constitutionality of the Georgia Obscenity Act. And the same thing happened in the Michigan case, and the court dismissed, they said that the search and seizure question was properly briefed by both parties, but then declined to pass on it and said that probable jurisdiction had been erroneously noted as far as that's concerned. However, I do feel that the court would have to pass on the search and seizure question, but right now I'm addressing myself to the constitutionality of the Georgia statute.
I want to be clear on one matter with respect to your position.
Yes, sir.
Now, here's some allegedly obscene films. I haven't seen them, but if I should decide that this case must be reversed on on the possession point or on the search and seizure point, Fourth Amendment points. I would not consider it, as presently advised, I would not consider it necessary to endure a sight of motion picture films, whatever their content may be. And do you consider that, do you disagree with that present thought of mine?
I disagree with it, Your Honor, so far as the First Amendment.
I'm not talking about the First Amendment. I'm talking about the 2 points that I'm talking about, namely the possession and the manner of seizure, which are Fourth Amendment points.
Well, Your Honor, I feel that the possession is the First Amendment.
And maybe the possession is a First Amendment point in a sense, but not in the sense that you're talking about, I take it.
Well, the appellant is asking this court to declare a mere possession count, I say mere possession with scienter, count unconstitutional.
But if we should conclude that a statute making mere possession a criminal offense is unconstitutional under the First Amendment, regardless of the nature of the films, then it obviously wouldn't be necessary for us to see the films, would it?
Your Honor, I take the reverse position. I've said that you should see the films, and if they are hardcore pornography and outside the protection of the First Amendment, as this court has held in Roth and a whole series of cases, then it would not be necessary for the court
but I say assuming that we felt, assuming that I should conclude that so far as I'm concerned, mere possession cannot be punished as a crime regardless of how obscene the film might be, then it would follow that there'd be no point in my seeing the film. Isn't that right? So that seems to me to follow as a matter of course. Now, I know your position.
Yes, sir.
Is that if the film is obscene,
right,
mere possession can be punished. But I say that if I disagreed with that, then obviously it would not be necessary for me to endure a sight of this film. I'm not characterizing it as obscene. I don't know whether it is or not, but it probably is not one of the greatest works of art that's ever been struck by the hand of man.
That's an understatement, Your Honor.
Your real point is, isn't it, that our approach to some of the legal questions might be conditioned if we saw it still?
Yes, sir, that's correct. That's what I mean. If
obviously that's quite irrelevant. It's not a debating point. I hope you're going to address yourself to the constitutionality of this statute. Mere possession without any purpose to exhibit, sell, or display.
Yes, sir, that was going to be my next point. To the best of my knowledge and research, and I believe my...
Let me ask you before you do that.
Yes, sir.
As I read the record, it seems to me that the only time it's established by evidence that the picture has been displayed in Atlanta was when it was displayed at the prosecuting attorney's office to a group of people. Is that right?
That is the only evidence that it has been displayed in Atlanta. I recall that Your Honor asked me... Yes, sir, you're right, sir. Thank you. They looked at it in the appellant's home. And yesterday, Justice Black, you asked me about what the expert photographer said. He said that the films are badly scratched, dirty. They are not in new condition at all. That was from where I had mistakenly said that they had seen extensive use. They are not in new condition at all. One reel rolled backward, never rewound after showing of the film. And he says, yes, sir, they obviously had been shown before.
But where in the record does it say they were shown in Georgia before? It doesn't say it at all. It says it was shown someplace before.
That's true, sir. We didn't have any eyewitness who watched this appellant show the film.
And the undisputed evidence was that the appellant had barely come into possession of these films that very day.
That was not evidence, Your Honor. That was in the form of an unsworn statement.
Well, you've been talking about it, though, as a basis for much of your argument.
Yes, sir. Under Georgia law, the jury can pay what attention to it wants to. It can either disregard it or believe part of it.
Are you suggesting that we should disregard that statement entirely?
I'm suggesting that the court should consider it and consider the deficiencies.
Well, if we do, then we know that he had barely come into possession of the film.
Well, I'm not saying that the court should believe it all in its entirety, because the natural thing for him to have done was, if that were true, to have brought the person in court, or at least named him so that the prosecution could have brought him into court. I have only a couple of minutes left, and I haven't even addressed myself.
You really mean bring him in court, or you would have arrested him, wouldn't you? Because he would have admitted that he had possession of these films.
It's entirely possible, unless he had denied it. He might have said, "No, sir, I don't even know Bob Stanley. Never saw him before." And certainly I didn't give him any films. Then we would have made a state's witness out of him to have proven the defendant made a false statement in his unsworn statement. On the question of which Justice Harlan asked me to address myself to, the constitutionality of a possession statute, I really see no reason why a possession statute making hardcore pornography obscene cannot be constitutionally enacted by a state. States have many possession statutes, and the court knows them as well as I do. Possession of stolen goods, possession of concealed weapons without having licenses for them, possession of narcotics, possession of dangerous drugs, possession of burglary tools. The federal government has many possession statutes alone. Possession of a car, stolen car transported in interstate commerce, possession of money taken in an FDIC bank robbery, many possession statutes, and even during Prohibition days, bare possession of intoxicating liquors of any type was an offense. And I see no reason why the possession of hardcore pornography should not be made an offense. And I know of no case I think this is a case of first impression before this court. I have not been able to find a case exactly in point. Now, in the Smith case, which this court admittedly reversed, but only because there was no scienter, it seemed to me that the opinion, which I've quoted from once before, indicates or implies that had the California ordinance had the element of scienter in it, that it would have been constitutional, because Mr. Justice Brennan said this: "We need not, and most definitely do not, pass today on what sort of mental element is requisite to a constitutionally permissible prosecution of a bookseller," as quoting, "for carrying an obscene book in stock."
For sale.
That is it.
For sale. For sale. What's bookseller mean?
Yes, sir, but Your Honor, the California ordinance did not have any element of carrying it in stock for sale. It just said possession. Absolute liability, absolute criminal liability.
That case did involve a bookseller.
It did
involve a
bookseller.
prosecution for having books for sale, didn't it?
And I cannot see, honestly, where the First Amendment grounds hit this particular case. This man is not a bookseller. He was suspected of being a bookmaker rather than a bookseller. He was not intending to sell these films, so far as the available evidence indicates. The general public was not deprived of the right to look at the films. The Georgia Supreme Court, in distinguishing this case from the Marcus case, said as much in its opinion. it said that the Marcus case on the search warrant, Marcus versus search warrant, it said that that case involves freedom of the press and freedom of speech. This case does not. And I don't think this case involves, under the facts of this case, this is just an individual. He is not being deprived of his right, though the public, I should say, is not being deprived of the right to view his films. I see I have the red light. If I might just... I might just say this, if I might be allowed one more sentence. I feel that a possession statute is necessary for effective law enforcement from the very type of evidentiary problem which has been pointed out by questions from this court. If you catch a man with the pornographic material, how are you going to prove that he has read it or that he has looked at it or that he intends to sell it? You can stop pornography at its source. And I honestly submit that this is the hardest type of hardcore pornography that this court has ever had before it. Thank you very much.
Mr. Asinoff?
May it please the court, with respect to Smith versus California, that prosecution involved a bookseller under an ordinance providing or referring to booksellers. Consequently, the sale, we're dealing with a person there who is in the business of selling books.
Give me your view of how you would argue the possession point, accepting the fact that the court has said that obscenity is not protected by the First Amendment.
In the Roth case, where that principle was established, we find that the Roth case was a question of distribution. And in an instance where an individual who is possessing something that we'll admittedly say is pornographic, the Constitution does not protect him from the distribution. And this is followed in the Red Rock case.
But the case said the obscenity isn't within the First Amendment.
That's correct. But the case was dealing with a question of the distribution.
You mean obscenity in the course of distribution is not protected, and obscenity just in possession is protected?
That's correct. The case did not hold that bare possession or mere possession was not protected. The court said in Roth that obscenity was not protected, but they were...
Well, the material doesn't change any, so what is the critical fact? The material, whether it's distributed or not, is the same, and it either is or isn't protected by the First Amendment. So what is different between possession and distribution?
Because...
What should you really focus on?
Well, in the distribution, you're dealing with a question of furnishing it to others. And the mere possession in your own privacy of your own home, where no one else has seen it, and there's no evidence that anyone has, or no one else is intended to come into contact with it. I say that no case holds that it is not protected, that an individual cannot take a picture of his own obscenity and for posterity for himself if he so chooses. Because to do so, to prohibit a person from possessing it, would in itself violate First Amendment rights. Because...
What do you say to your adversary's argument that the state constitution says we'll nip this business in the bud by suppressing it if the state possession, given the hardcore pornography, whatever you want to call it? What do you say about that?
That in itself would be a violation of the First Amendment. To say that a person could not write what he wants in his own diary, let's say, that he's going to keep for his own personal future in his own drawer, not to be shown to any other persons. We say that the First Amendment is an absolute amendment that gives the man the freedom of the press, and the freedom of the press carries with it the freedom of motion picture films.
Well, the court has held, at least the majority has held, that it is not an absolute right in the obscenity of the majority.
But that was held in the Roth case, if you're please. And the Roth case involved...
That's right. What your adversary is saying is that the state legitimately again on the premises that what's involved here meets the law.
Then we come into the Red Rupp case.
About not waiting for sale, it's got a bird or something.
Well, then we come into the Red Rupp case, which was decided since Roth. And this court last year in Red Rupp and the other cases that went with it reversed on the theory and on the principle that that this was not a case involving one of the three elements, either distribution to minors, distribution to persons who are unwilling to see it, or pandering, as was held in Ginsburg. Now, if we accept Red Rupp as being the law, then of course we must take Red Rupp and Roth together, as they both hold, and say that obscenity, insofar as its mere possession and bare possession, and I use that expression, the bare possession is concerned, would be protected by the First Amendment, because there you are not intruding upon the privacy or the rights of others to be free from this stuff. Now, in the finding, one thing I would like to answer my opponent with respect to, he says that the state court found that the state statute did not remove the element of scienter. Now, the rule, as I understand it, is that this court will accept an interpretation placed upon a state court as to a non-federal ground, but as to a federal constitutional ground, this court is not precluded by virtue of a holding of a state court on a constitutional issue from reversing that state court, because this is the final arbiter. This court is the one that must decide the federal ground. Now, secondly, in the brief of the appellee on page 45, he cites the case of Rainwater versus Florida, which was decided by this court during the last term. The Rainwater versus Florida case was one that originated in the state court. There was a federal search warrant issued under the Wagering Tax Act, certain items from the defendant's possession, and they prosecuted him in the state courts. This court remanded that under the theory of Grosso and Machete, remanded it back to the state court for further proceedings, not inconsistent with Grosso and Machete. This is identical to the case we have here. The state says in its brief that there, the prosecution in the state court was the end result of the issuance of the federal search warrant. That's what we have in this case. This prosecution for obscenity was the end result of the issuance of the federal search warrant, which actually, under the Rainwater versus Florida doctrine, was inadmissible as having been unconstitutionally obtained. Now,
to get back to this possession point, under the state law, if assuming that possession were a crime, mere possession was a crime and not barred by the First Amendment, could the state get out a search warrant to search your own library on the basis of an affidavit that would say that you have in that library a copy of James Joyce's Ulysses, and a copy of this book and that book, and that there was, and therefore they get out a search warrant to examine your entire library?
I would not think so. I think that the Constitution, the Fourth Amendment, says that the warrant shall particularly describe the articles to be seized.
In other words, that they'd have to name the specific book.
That is my view of that amendment. Now, one point that was raised by my adversary, he says that the evidence in the case indicated that one reel of film had been wound backwards or was scratched, and that would indicate that someone had previously viewed that film. But it would not show, and we submit to this court, that fact alone could not and would not show that this defendant or this appellant had ever viewed them. Now, in conclusion, I would like to state that since my opponent has, or my adversary, has suggested to this court that this court view the film, he has in effect stated that how does this court know that they are obscene without viewing them? Now, that is our very position in this case. We say that with respect to the appellant. The same position holds true. If he has never viewed the films, he would not obviously know that they were obscene, because without viewing them, you cannot learn of its obscenity. And that is the point that we have in this case. We say that since the evidence doesn't show that he ever viewed the films, that therefore there's no evidence that he knew or could have known that they were obscene.